Dear students, this class we are going to discuss about the panel process, the entire panel process which is provided under the WTO dispute settlement understanding. So, panel is the preliminary body, adjudicatory body in all the cases to be dealt by the panels, and they come out with the reports and which may be appealed or which may not be appealed. If it is not appealed, then it will be adopted by the dispute settlement body and it will become a final ruling. So, if it is, if any one of the parties preferred an appeal, it will go to the appellate body. So, here we can see the panel process is a very simple process which is different from the GATT process. So, we said that the GATT, even though they started the adjudicatory system through third parties, that is the panels, and there was no procedural aspect which was prescribed, specific aspects was prescribed or specific qualification is prescribed. Usually the government officers, they sit as panel members and they come out with reports. And in the WTO system, it is not a permanent panel, is not a permanent body, but it comes out with independent panel members which are not related to the parties. So, these panel members, this the panel system is the initial stage of dispute settlement, the first stage of dispute settlement. And the DSU encourages members to settle their disputes through consultations before the panel is formed. And the WTO Director General also may offer his good offices or mediate to achieve a solution through conciliations. And panels are considered to be a quasi judicial bodies or tribunals, and the members adjudicate the disputes. And normally they composed of 3 members and exceptionally 5 members purely appointed on ad hoc basis for individual disputes. So, it is not a permanent body and they are absolutely appointed as ad hoc bodies for a particular case, and no permanent panel members, and different panels for different cases are formed. So, the qualification says they are well qualified and independent people can serve as panelists, and the persons, the panelists, those who are well versed in international trade law or former diplomats, also they can become the panel members, or those who have worked in the secretariat. So, those who have taught or published on international trade policy, trade law, senior trade policy, senior the officials of the governments, they can also become the panel members. So, always the WTO Secretariat maintains a list of names nominated by the governments, non-governmental persons. So, the panelists may be drawn. So, the panel WTO members can propose the names for inclusion in the list and approves their inclusion without any debate. So, that means the panel members, so the every country can propose the panel members as a potential panel member in specific disputes. So, after the consultations failed, if any member wants to constitute a panel, so the request, a specific request is to be sent in writing. So, it should indicate the details of the consultations when it is made and identifying specific measures at issue or which are the agreements and the provisions violated by the other member, and also the summary of legal basis of the complaint. It means not mere allegations or conjecture, clear cut identified legal basis of the dispute to be presented along with the request. And then the panel members is, as we already said, that they may be well qualified governmental, non-governmental people, secretariat officials, or trade academicians, lawyers, and they will be appointed by the WTO, the DSB, for adjudicating a particular case. And the most importantly, the most important criteria is that the panelist shall not be the nationals of the parties. It means that they are going to be 100% independent. They are not going to be belongs to a particular state of parties, those who are in dispute. And the third parties can join. Those who are interested in the particular dispute can join as third parties. So, the parties should ask the WTO Director General to appoint a particular panel, and then it works like a completely a judicial body. So, there will be oral statements, written submissions, and adduce of evidence, and even the panel can use the support of experts, scientists, and there can be an interim report, and there can be a final report, then finally the adoption of the report by the dispute settlement body. In short, the panel process, and finally the reports will be adopted. So, all these are going to happen only if the consultations, there is no agreement was concluded after the consultations. So, the violations should be very clearly mentioned, and also you can see that the terms of reference of the panel should be clearly mentioned. Now, we see what are the powers of the panel members, what actually they are supposed to do. We said that adjudication of the particular dispute which is given to them, but what are the principles to be followed by the panel members, what are the powers of the panel members. So, the basic rules of panel proceedings are found in the article 12 of the DSU, and the article 12 says that the panel should follow the working procedures prepared by the WTO contained in the appendix to the dispute settlement understanding. And so, the panels are authorized to adjudicate the dispute. See, one of the first cases, India patent case, the appellate body has mentioned, appellate body has clearly elucidated what is the role of this panel and what is the power of the panels and what are the duties of the panel. I quote, although the panels enjoy some discretion in establishing their own working procedures, this discretion does not extend to modify the substantive provisions of the DSU. To be sure, article 12(1) of the DSU says panel shall follow the working procedures in appendix 3 unless the panel decides otherwise after consulting the parties to the dispute. Yet that is all that it says. Nothing in the DSU gives panel the authority either to disregard or to modify other explicit provisions of the DSU. So, the appellate body made it clear that the panels cannot exceed the working procedures. They have to follow the working procedures under article 12(1) mentioned under article 12(1). So, the panel should act according to the working procedures. So, the procedures, unlike the GATT dispute settlement system, the procedures are clearly mentioned. And third parties are a group of countries those who join a particular dispute other than the disputants. Any country those who are interested in a particular dispute can join as third parties, and submissions of third parties also will be accepted by the panel, and opportunity of written and oral submissions are also to be made. And what is the impact of these written and oral submissions are not clear, but definitely the panel is going to consider the written and oral submissions of the panel like the disputing parties, because they want to protect their own interest. That is why third parties are allowed. So, they should be heard. They should be heard before the panel come out with the reports. and the panel reports are adopted by consensus. We said that by negative consensus, and it is once it is adopted by the DSP, it takes effect, that is binding on the parties to the dispute. And also the duties of the panel, which we said, what the appellate body clearly said, their powers are very limited to the extent of the working procedures. And Article 11 clearly says what they have to do. Article 11 says the panel should make an objective assessment of the facts of the case and applicability and conformity with the agreements. So, the panel really look into the facts of the case as well as the law, violation of the provisions. So, and ask the member countries to in compliance with the procedures. So, mutually agreed solutions can any point of time they can come out with mutually agreed solutions. So, if the parties have any dispute with regard to the implementation period, they can go on with arbitration procedures under Article 21. And in case of non-compliance, a review panel will be formed, and the review panel can give compensation under Article 21(3) or order for suspension of concessions. We talked retaliation, cross retaliation. The members, the review panels have the powers to go on with retaliation and even cross retaliation. So, the parties will be given only one chance of arbitration under Article 21(3), not two chances. And this arbitration panel have the power to authorize, suspend concessions. So, it means that arbitration panels are very powerful, and there is no appeal which you can find it from the arbitration panels. So, arbitration and Article 25 says that, so this arbitration should be promoted outside, but no members will go outside, and they will come back to the panel, the arbiter panel, and the panels will sit as arbitrators, even though they are used other mechanisms of arbitration that they won't do. We already saw this particular the flow of process, consultations, panels, then the terms of reference will be given, then panel of the panel will be given, and then the panel will examine or they adjudicate the case. They come with an interim review, then they come out with the final report, the panel report, then panel report will be circulated to the members, and finally, the panel report is adopted by the DSP members. And if the report is adopted, if the parties are not going for appeal, otherwise the parties go with their own appeals. So, the total time frame is mentioned, clearly mentioned, and first stage is the hearing of the complaining parties, and there can be rebuttals by the opposite party. Then we said that the panel have the powers to appoint scientific or other technical experts to consult the experts and to take advisory opinions of these particular experts. Then the first draft of the report will be ready, and then interim reports will be issued. Then the period of review, 2 weeks time is given, then the final report, and the report become a ruling once it is adopted by the DSP. This is the panel reports. And written submissions, the members, we are given ample opportunity of 2 written submissions to the panel, and the panels meet twice the parties to the dispute. So, and accept and definitely the parties, the deadlines are to be met by the parties, and then all the deliberations of the panel are confidential, and the panel report is drafted in the absence of parties. It means that it is a completely independent adjudicatory body without any kind of interference from the parties, and the panelists, they used to meet and draft the report. And interim review is very important. Once the draft is complete, then they look into the factual aspects and the law, the violating law, and then the comments will be accepted from the parties, and the comments will be considered by the panel after the interim review is done. And the final report is again, you can see that in main languages, the WTO languages, and it is circulated to the WTO membership. Once it is circulated to the membership, so it is an unrestricted document once the report is circulated to the members and available to the public. So, all the panel reports are in the WTO site, and the hard copies are published by the Cambridge University Press Arts volumes. So, all the final reports are in the public domain. So, if the report, if any party is want to go for appeal within a period of 60 days, its intention is given to the panel, and then they go on with the appeal. So, within 20 days of time, the reports once circulated, they have to show their intentions, they have to send their intentions for appeal to the panel, and the appellate stage, the appellate body considers the appeal and gives the final appellate body report, and we will see in the next class. So, adoption of the report here also is very important. So, the nobody have, only again the WTO members meet together, and automatically it is adopted on negative consensus basis, and once it is adopted by the DSP, and the report is legally binding on the members. And so, as I told you, if the report is not going to be adopted, if there is no complete negative consensus, as it is reported that only once it is happened in the entire WTO period, the report adoption is not happened. So, the rights of the parties are very clear, in the rights of the parties are very clearly mentioned, a right to fully participate in the process. So, giving written submissions, oral submissions, and making objections, and also after the interim review report is circulated, the comments also is to be submitted. So, the panel report is the ample opportunity is given to the parties for submitting their views. And we always say that there are special provisions which you can find it for the developing countries, and there is special provision here also you can see. But what kind of special concessions will be given to the developing countries is not clear. So, the provision says that the consultation time, special consideration to be given to the developing country members, their problems, their interest. But even though it is a hard law provision, most of the developed countries consider it as a soft law provision, and they do not give any special concession to the developing countries. So, it is always the special and differential treatment become only in the papers. So, so we talked about special and differential treatment, and in many cases, for example, in the India quantitative restrictions case, India requested for the panel, so additional time as a special and differential treatment, and additional time in order to prepare its first written submission. So, United States actually objected to the request of India. So, even there is a provision, Article 12 very clearly says that special consideration should be given to the developing countries, but mostly the developed countries rejects. As I told you, in India, the US made objections for some additional time for submitting written submissions. And as I told you, these special provisions, even though there are a lot of special provisions in other agreements also, these provisions the developed countries do not give any kind of concessions to the developing countries. So, it is always considered as a dead letter. So, when we consider the dispute settlement as a panel, the panel is the third party adjudicatory independent body, independent preliminary body in the dispute settlement. The contribution of panels so far since 1995 is immense. And the contribution of panels and its impartiality and transparency made it is very important for the independentness of this entire dispute settlement system and the reliance on this particular system by the member countries, overwhelming reliance of WTO members in this particular dispute settlement body. So, there is so far there is no complaint neither of corruption nor of partiality came to the WTO dispute settlement panels. So, the panel members are highly qualified, experienced people, those who dealt with the cases, and mostly the provision very clearly says that no member country the panelist can sit in their own represent their own country. So, always the other country members sat for the dispute resolution, which increases the credibility of the system, which increases the predictability of the WTO dispute settlement system. So, thus the panel formation is absolutely different from the GATT in WTO, and there is a written rules and working procedures for the panels, and the panels can only look into the violations and related facts and also the violated laws, and the panel do not have powers to exceed the working procedures. So, there is a clear framework of working of the panel and within the written rule based system. So, I would say that in conclusion, and panel is working so far very well within the WTO system, and unfortunately only panel is there now in the WTO dispute settlement system. So, in the next class we will talk about the death of WTO appellate body and how the appellate body worked so far. Thank you.